Up next is Scott O'Connell from the Boston office of Nixon Peabody, where he is Deputy Chair of Nixon Peabody's Litigation Department, as well as Practice Group Leader of the Commercial Litigation Team and the Class Action Aggregate Litigation Team. He represents integrated financial services companies, including banks, securities firms, insurance companies, and regulated subsidiaries of non-financial parents in federal and state court and before regulatory agencies. Scott has extensive experience defending financial institutions in class actions concerning lender liability, breach of contract, breach of fiduciary duty, breach of good faith, unfair and deceptive trade practices, fraud, misrepresentation, fair debt collection practices, and civil RICO. He has particular trial experience litigating complex financial relationships between parties, unfair and deceptive trade practices claims, corporate control issues, including corporate freeze-out, lender liability, and civil RICO. And this is just hot off the presses. Scott was just named Best Lawyers 2013 Boston Litigation Securities Lawyer of the Year. Only a single lawyer in each practice area in each community is honored, and Scott is that Lawyer of the Year. Here he is to discuss the continued erosion of overbroad class actions is Scott O'Connell.
Thanks, John. Thank you, John. I too assume that that's a fraud. I don't know when it'll be corrected. I keep watching my iPod to determine when Best Lawyers recalls it, and I understand there's already a bunch of lawyers in Boston who've started a fraud on the market litigation, so details at the next seminar.
You have it on your iPod?
iPhone, sorry. Yeah, something. I'm going to pivot to class actions because while many of you are governed by FINRA rules and they're well established and you don't have to deal with some of the things I'm going to be speaking about, as Joe Cohen talked about earlier, many financial services firms find themselves betwixt and between the rules of civil court and arbitration. And for the past 30 years, efforts by consumer-facing companies to get into arbitration have found their way before the Supreme Court, and 2 terms ago, our Supreme Court gave great clarity and great endorsement for letting all of you who are consumer-facing companies contract your way out of court and into an arbitrable forum. And that decision, the AT&T Mobility versus Concepcion case, is cascading its way through the federal courts and is creating all kinds of opportunities for your companies and the defense counsel in this room to get cases out of scary jurisdictions, scary courts with scary juries, into a place where you're dealing with a singular claim without class allegations. So let me dive into that and talk for a couple minutes about AT&T Mobility, and then talk about a recent decision out of the Ninth Circuit that I handled, which has made clear that some of the provisions of California state law under 17200 are unconstitutional or in conflict with the FAA and need to be preempted. And that's good news for all of you companies facing very consumer-friendly forums like California as a way to get out of court. But let's talk about Concepcion for a minute. It was a close decision, divided court, 5-4. The arbitration provision had a class action waiver, and it was upheld. It was a case that came out of California. So it was another Ninth Circuit decision. The Ninth Circuit was flipped by the Supreme Court, and the outcome of that case is the so-called discovery bank rule, which had provided under California law that class waivers were in conflict with state law, was overturned. And Discover Bank became the model of law that was adopted in many jurisdictions. And for those of you who work in other parts of the country, you saw your own version of Discover Bank. And we'll talk about what has changed with Discover Bank and what is now at risk and gone under 17200. But first, the Federal Arbitration Act is what is the basis for everything you're going to hear. And it's been the federal policy since the Federal Arbitration Act was enacted to provide support for contracts that provide for arbitration. But notwithstanding that stated federal policy, it's been hard, as many of you know, to get out of court and into an arbitrable forum. But it's pretty plain on its face. Agreements to arbitrate that are valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract, will be enforced. So the battle has been pretty much on that last phrase, save upon such grounds as exist at law. That's the exception that has swallowed the rule in some jurisdictions, and the Supreme Court has said, no, we're not going to let that exception gobble up what is the stated policy, the mandate of Congress, that arbitration provisions will be enforced. The exceptions to the enforcement of these types of agreements are issues of fraud, duress, and unconscionability under state law. And fraud, duress, and unconscionability, that is not particular to agreements to arbitrate. So in other words, it has to be a state law that applies to all causes of action. Any state law, as we'll talk about, that on its face tries to limit the federal mandate for arbitration is unlawful. Discovery bank rule. Here it is in all its glory. Let's chop it up and talk about why this was scary for so many consumer-facing companies. So anytime you had a consumer contract of adhesion, and everyone in this room has a consumer contract of adhesion under traditional definitions, there's no negotiation for your standard forms. Consumers generally have to take what you're offering or not. And the question is, are there other options in the marketplace? Do they have the ability to find other providers of the services that you're looking for? Discover Bank was concerned about the fact that often consumer-facing companies were getting into a situation where small amounts of damages were being implicated, which made it not logical or not economically viable for the plaintiff's bar to proceed for those damage claims. So the notion that small damages, when aggregated, make a meaty claim, and policy in the law of the United States would suggest you need a mechanism, a class action, to make it viable to vindicate those rights. And also at issue were schemes to deliberately cheat large numbers of consumers out of individually small sums of money. Same concept. And when there's a class action waiver in a contract, California used to say that that would be an exemption of the party from responsibility for its own fraud or willful injury to the person or property of another. Well, that's a pretty consumer-friendly statement. It's assuming that the people with whom you're dealing with need the class action mechanism to vindicate any types of small damage claims when you're dealing with them in a contract adhesive environment. Well, that's bad news for every corporation in the room. But let's look at the FAA preemption for a moment. When state law prohibits outright the arbitration of a particular type of claim, the analysis is straightforward. The conflicting rule is displaced by the FAA. When state law prohibits outright. And what Concepcion reinforced was that any law, California consumer law, the one at issue in Concepcion and the Kilgore case, needs to yield to this national mandate to enforce arbitration. The Concepcion case came down a year and 4 months ago. And since then, as I said, it has been applied by district courts and courts of appeals across the country. I'm going to talk about this case, Kilgore, which I've been handling for the past 4 years, and the decision that came down in March. Before the court was a claim under the unfair competition law in California, 17200. Now, that has been the scourge of companies for a long time because in its former life, it was a private attorney general statute. You didn't have to have recognized standing. You didn't have to have an injury to bring the claim. And over a series of legislative changes, that statute had been beaten back. However, it still was a potent weapon by the plaintiff's bar to come at companies and try and stop offending conduct. At issue in this case was the closure of a helicopter school, national helicopter school with locations in California. The plaintiffs, putative class of students, very sympathetic crowd. They borrowed tuition money from my client, KeyBank, and the school closed precipitously. And the question was essentially whether the lender, the bank here, needed to stand up and be an insurer for the failures of the school. Pretty sympathetic plaintiffs. They didn't get their education, yet they've got to pay their tuition. And in a consumer-friendly forum, doing that case as a class action in court was something that raised some concerns. But the promissory note at issue had an unmistakable arbitration provision, which said you don't get to proceed in court if the bank wants to proceed in arbitration, and you don't get to do it on a class basis, on a representative basis. You're only allowed to bring your individual claim. We brought that forward in the Northern District of California, Judge Henderson, who denied the claim to compel arbitration. And in what is an anomalous circumstance in California, or the Ninth Circuit, the district court retained jurisdiction after that denial. Just about every other circuit, you automatically go up on appeal and you get a decision as to whether you're going to arbitrate, but not in the Ninth Circuit. They've got different rules. So this case went on, and we ultimately got it dismissed on the basis of national banking preemption, that what the students were trying to do in this case was read new terms into the lending relationship. And under the National Banking Act, that would be preempted. State law can't do that. But we had to go up on appeal on both issues. And so consolidated at the Ninth Circuit was our motion to compel arbitration and the plaintiff's motion to overturn the dismissal of the case. What happened? Oh, let me go back, Ed. The one thing that's important and guiding out of the Ninth Circuit is, but the very nature of federal preemption requires that state law bend to conflicting federal law, no matter the purpose of the state law. The question in California with 17200 was whether or not state law that said certain types of public injunctions, which 17200 provides, was a carve-out from this national mandate for arbitration. And there is a long line of cases, the Broughton-Cruz line of cases in California, that said, yep, that's a recognized exception. If you're vindicating a public interest, then you're not subject to arbitration. And what Kilgore stands for is that that line of cases is in conflict with the FAA, and the statement at the bottom of the screen is the rationale. Court found, I'm sorry, there may be a noble purpose. The legislature or the courts that have determined that this public exemption, the state legislature that is, might be better vindicated in a court of law, still gets swallowed up under the FAA. And so now the law in California, Ninth Circuit, is that if a plaintiff brings a claim forward for a public injunction and you have an arbitration provision, you can get it out of court and into that other arbitrable format. So even if there are notable policies that undermine or that stand behind the notion of not providing for arbitration, Kilgore stands for the proposition and the extension of Concepcion that that's not enough. You're still entitled to arbitration. Now, what does that mean for all of you who have arbitration provisions? Tell your defense lawyers to read Kilgore. Get out there and say, we may have abilities to get out of court and into arbitration and have a class action waiver sustained. The other part of Kilgore that I would commend to you, which is relevant for the analysis, is you still run the risk in any type of contract for arbitration that under the state law it could be found unconscionable. That is one of the recognized exceptions that Concepcion had reiterated. Now, what's good about the Kilgore decision is that the Ninth Circuit looked at the waiver provisions in the promissory note and gave very unmistakable opinions as to whether or not it was consumer-friendly and unconscionable. Now, let me spend a minute to talk about the promissory note because it may have relevance to the kind of waivers you use with your clients. This promissory note said that regardless of your reason, if within 60 days of signing this note, you want to opt out of the arbitration provision, you can do so. You can do so by providing notice as provided for in this promissory note. Now, the plaintiffs were heard to say, that's so confusing. They actually have to send something to the bank to opt out? And the Ninth Circuit laughed at that argument. They said, this is about as consumer-friendly as it gets. Tell the consumers what they need to do and opt out. And in our case, no one did. And without any opt-outs, there was no claim for unconscionability. And so if you've got that kind of contract, look at Kilgore, because California is tough, very consumer-friendly. And I'll suggest that if your contract matches the types of provisions that this promissory note contained for opting out of the arbitration, you've got some ability to say, we're in good shape, company. We've got the ability to withstand any type of unconscionability challenge. So put it in the hands of your defense counsel, look at it yourself, see if you have what the Ninth Circuit called clear, easy to follow instructions as far as getting out of the arbitration provision. A couple other points that are worth making. You know, often plaintiffs' bar will argue things on unconscionability about the sophistication of the borrowers, those who are generally the plaintiffs in these actions. And Kilgore beats that notion back, at least on its face by itself. The lack of sophistication in and of itself is not going to be enough, at least in the Ninth Circuit, to get you out of a valid and enforceable agreement to arbitrate. The other thing that was nice about this provision in the promissory note is that there was some real clear representations by those signing the promissory note that said, the promise from the student that he or she has read the contract carefully, even if otherwise advised. I mean, how often have we heard the defense, well, I was just given this pile of documents and told to sign. Think about adding some language like that to your contracts. It's never going to be a defense if a client is, or a plaintiff is signing the dotted line saying, I have read this and I'm saying it's true and accurate, or I'm signing it of my own free will, even if I've been advised not to read it. Pretty powerful stuff. So the court concluded, we will not relieve plaintiffs of their contractual obligations to arbitrate by manufacturing unconscionability where there is none. Wow. Great business-friendly decision from a circuit that's not known for being that way. So think about whether or not you've got a contract that needs to be looked at for this type of unconscionability. Kilgore is a good way to test the metal through the crucible of the Ninth Circuit. You know, for the last minute or two, I just want to turn your attention to what is out there in the ether as to whether or not Concepcion is subject to further limitation. This is a great decision. It's the kind of thing that will continue to ripple as I've described. But under Dodd-Frank, we now have this Consumer Financial Protection Bureau, and it has taken as one of its first missions to look at the use of class action waivers to determine whether it's being abused by consumer-facing, principally financial services companies. And by the middle of the summer, the public comment period as to the use of these things had run, and so it is now in the hands of this organization to report back to the public and to Congress as to whether certain limitations are necessary. For those of you who use these types of agreements, I would alert your public government relations people that it's out there. They probably know about it, and make sure you're following this. And if you want to be heard, get out early, get out often, because arbitrations, as others have discussed, is a wonderful way to take what could be a very scary aggregate litigation with millions of people and tens of millions of dollars at issue and break it down to an individual claim in a forum that's not expensive and scary and full of potentials for punitive damages as a runaway jury. This slide describes what the Consumer Financial Protection Bureau is studying, and I would expect that sometime this fall, all of us will learn the outcome of that, and the next battle will rage probably after the election as to what may change in Congress as a result. So thank you for your time and attention. I appreciate it. Hope you enjoy the rest of the seminar.